All right, 25 minutes before 11 o'clock. Thank you for tuning in. It is time for the program called Legally Yours. It is hosted by attorney John B. Fuller from the law firm of Fuller and Fuller. The other Fuller is not here. She is Janet Fuller, John's wife. And John is here to answer your questions. And one of the biggest questions you all have right now is this live or is this tape? And that's why I'll tell you the date. If this date is the date on your calendar, then you're listening to a live show and you're invited to call in 622-9622. The date is Wednesday, January 8th, 2014. I know John's been out for the last couple of weeks because of the holidays, but he is back live January 8th. So if your calendar says it's January 8th, that you're listening to a live show. Good morning, John. How you doing?
Good morning, Larry. I'm good. And good morning to our listeners, and Happy New Year to you and everyone that is listening. We hope you all had a very happy holiday. And it was kind of unusual this year because we had both Wednesdays, the last two Wednesdays. One day was Christmas and one day was New Year's, so we were not able to be here live, but we're happy to be back, excited about a good 2014 coming up, and look forward to talking with our listeners, and if hopefully people will not have legal problems, but inevitably issues do arise. And if there's something that we can help with at our practice of Fuller and Fuller, well, we certainly invite our listeners to give us a call at the office, and we'll be happy to set an appointment and talk with you about the specifics. This show, as most of our regular listeners know, is to answer questions in general terms that our listeners may have about a particular legal problem or question that they or someone in their family or friends may be experiencing, or something about the legal system. We don't address the political ramifications of that, but obviously our judicial system is a part of our government, and it overlaps. Yeah. But that's pretty much what our goal is. We've been doing this now for a little over 2 years, and it's been a real joy.
When somebody is facing a court date, thank you, Robin, I'm guessing that they are nervous. From an attorney's perspective, are you just so busy you can't be nervous about it?
Well, absolutely not. I think you make a great point, Larry. I've never had a client who had an issue that went to court, went to trial, that wasn't nervous. I think we're all human beings. We all have a certain concern about the unknown, and no one can predict with certainty what the outcome of a trial or hearing will be. I've been blessed to do this 40 years, and I've never been to court yet that I wasn't nervous and didn't have butterflies.
Oh, really?
And I've heard almost every trial lawyer I know has the same feelings.
And you have a phone call. And just to recap, everybody who was interested in calling John, this is a good time to call. You'll be kind of ringing for a while we get through the callers. But at the end of the show, often you get questions in too late. So call now, 622-9622. You do have a first phone call. Good morning. You're on the air with John Fuller.
Yeah, good morning, Mr. Fuller. Listen, I have a question. A friend asked me the other day about this. He's a convicted felon, and he's married, and his wife is not. And I was talking to him, and he said his wife has a separate bedroom than him. And anyway, he wanted to know, he asked me, could his wife have a firearm in her bedroom, in her house, in her possession, even though he's married? They're married, he's a felon. I mean, can you answer this question? Thank you.
Yes, sir. If an individual is a convicted felon, they cannot have possession, which is generally defined as a firearm in their where it is readily available to them. So even though his wife is legally entitled to possess a firearm, if they are living together in the same home, he would not be able to have possession of that firearm. Could she take steps to absolutely secure that weapon so that it would be undeniable that he did not have access to it? That would be a fact question, and it would be something that the concern would be that he would have constructive possession of it by being in the same home, in the same domicile with his spouse, even though she was entitled to have it. If it was in the house where he had access to it by virtue of living in the same house, then under those circumstances, he could be at risk for being charged with possession of a firearm by a convicted felon. One of the remedies that would be available to him is to apply to for a pardon, to have his civil rights restored. And this is a two-stage process. Merely having your civil rights restored, which after you have served your sentence and completed any parole or probation terms, done everything you're supposed to do, you can apply to the governor and the cabinet and have your civil rights restored. This allows you to vote. It allows you to enjoy all of the rights of citizenship, except own, possess, or use a firearm. You have to get an executive order from the governor, signed by the governor and approved by the majority of the Florida cabinet, that specifically restores your right to own, possess, and use firearms. And that is an administrative process where you file a petition. The court not the court, but the governor and his staff and the cabinet review those cases and determine if a person is deserving of having his or her civil rights restored, and secondarily to have an executive order that specifically allows them to own, possess, and use a firearm. Obviously, it depends a lot upon what was the nature of the felony you were convicted for.
Probably, yeah. Yeah, makes sense.
If you were convicted of armed burglary, the chances of getting that restored is a lot more difficult than if you were convicted for having just slightly more than the minimum amount of marijuana to go from a misdemeanor to a felony. Was it a crime of violence, or was it a nonviolent criminal offense? A lot of those things are issues. Was it a one-time case where the person made a mistake, got convicted, served their time, paid their fines, paid their debt to society, and had been a model citizen before and after this one-time event? Or was it an individual who had had multiple criminal cases over a long period of time, finally culminating in a felony offense that led to the prohibition of possessing a firearm? So those are the things that I would caution somebody about.
The phone line is open if you'd like to call John. The number is 622-WOCA. That was a great question. The question I have, because of his question, is how would the law enforcement know about it, or could you know what I mean? Not that how would they know about it. So how could they get in trouble at all if nothing ever happened? If the gun was in her night table in a different room?
And you know, that's the classic question in our law. Let me give you a quick example. I don't mean to be facetious with it, but let's say that there is an intersection, and the intersection is controlled by a red light, a traffic light that turns red and green. You know that it's against the law to drive through an intersection when the red light is facing you. But you drive through the intersection and you run the red light. There is not another car within 20 miles of you. There's no law enforcement officer. There's nobody there. There is no wreck. Nothing happens. You drive through the red light. Technically, you have violated the law. But nothing happens because no one saw it. No one was hurt. No one was involved. You go and do the same thing and there happens to be a school bus loaded with children, and you run into them, and it's a whole different scenario. The same law, the same intersection. It's a question of who is caught and who is not caught.
So if something happened at the house and the gun was used, then that would become an issue. Otherwise, it wouldn't really be an issue.
Or somebody comes in the house and knows the gun's there, knows the individual's a convicted felon, and say, "Hey, I'm the housekeeper at that house, and I was dusting the cabinet, and sitting on top of the night table was a loaded handgun, and this guy's a convicted felon."
Yeah, that's a good point. All right, let's go back to the phone. Good morning. You're on the air with John Fuller.
Yes, good morning, Mr. Fuller, and Happy New Year.
Good morning. Happy New Year to you, sir.
Thank you. If you have a friend who's a citizen of a foreign country, can they visit and they carry a weapon, a concealed weapon in that country? Can they bring that weapon to this country? And if there's a problem there, can they get like a special permit to have it in this country?
That is way beyond the scope of anything I would be able to tell you on this program. We don't know what country, we don't know what laws are in the country, we don't know what treaties have been ratified, adopted, and confirmed by this country. And if anybody has a scenario that they are faced with that type of thing, I suggest they go hire some lawyer who would undertake to get all the facts that were relevant and to research it. But that's a very complex issue involving so many unknowns that I would be totally uncomfortable in even trying to offer some suggested principles.
Do you think a person like myself could get that answer, like going down to the courthouse in town here and finding somebody that would have an answer for that?
I doubt it seriously. The people that work at the courthouse are not allowed to give legal advice. They answer questions about a lot of issues that deal with permitting and that sort of thing, but I doubt seriously that there would be anyone at the courthouse who could provide you with the answer to that. Certainly never hurts to call and ask, but that's a very fact specific, very case specific, involved complex question, and not something that I don't think that anyone could give you an answer off the top of their head that would be meaningful, because there are just too many things that are unknown.
Yeah, the person concerned here is a law enforcement of the country that he's coming from, a law officer. And I was just wondering if that wouldn't have any effect on the case or not. But
well, if you're talking about a foreign country, that's the thing that throws it. There are provisions, and most states have adopted a reciprocal former law enforcement act. Some states have not, but most states have some provision that if a person has served and is a former bonded and licensed and certified law enforcement officer, and if that person continues to meet the qualification criteria of passing an annual shooting test and qualifications, that even though they are a retired law enforcement officer, they are still lawfully authorized to carry a concealed weapon, and most states have that, and most states give reciprocity to that. But there's a big difference in dealing in state laws and reciprocities and dealing in foreign countries. So I couldn't help you.
All right, thank you for the call. Let me take another call here. Good morning. You're on the air with John Fuller.
Good morning, Mr. Fuller.
Good morning.
I'd like you and your lovely wife a happy New Year, and also to Larry and the staff there.
Well, thank you.
And,
Thank you.
Always good listening to you. I have a question.
Yes,
young man was working, and he had apparently got behind in his child support, and his license had been suspended, and he didn't know it, and he got caught again. He got caught for driving with suspended license. However, he had caught up his child support, but he still ended up going to jail until he got a lawyer and got it straightened out, which I think is kind of ironic sometimes when you get in that system, you end up with all kind of court costs and all kinds of stuff. And here's a young man that really was trying to pay his support, which I think is kind of stupid anyway. If the guy doesn't have a car and he's probably going to lose his job or whatever. But my question is that considered a felony when you get locked up like that, or what's the deal on that? Like I said, it's sometimes you look at the courts and you look at all these fees and all the different things that they do, and it really makes it hard. It turns into a revolving door for somebody, especially if they're poor and struggling. And here's a young man probably end up, if he loses his job, he's not going to be able to pay his child support. Then he's going to end up probably back in jail, and we as taxpayers going to have to support that. But it's just, anyway, I'm just going to hang up and see if you could advise me as to whether or not he's going to be convicted felon. Have a good week.
Yeah, thank you, and thank you for calling, and happy New Year, and best wishes to you and your family too, sir. That's a good question, and sometimes the results of the laws that we have are very harsh. They're designed to protect children and to give enforcement, meaningful enforcement, to the judges to see that parents who are ordered to pay a certain amount of child support pay it, and pay it timely. And if they fail to do so, that there are consequences to that behavior, because the inevitable consequence is that if someone fails to support their child or children, and one parent is not able to do so, those children ultimately end up being an expense on society, and taxpayers end up supporting children that have been fathered or by a mother, it's gender neutral, who is not a responsible parent. And it does provide that if there is a child support order and an income deduction order, and the person does not pay the court-ordered child support and becomes in arrears, that their driver's license can be suspended upon a showing of the arrearage by a certificate of the Domestic Relations Division clerk, where the payment is supposed to be made through the central depository. Now, having said all of that, the way to avoid that type of a harsh result is the punishment is premised upon the fact that a person responsible for paying child support willfully fails to pay it with the ability to pay. And so the willful, intentional failure to abide by a court order to support one's children is what the punishment is designed for, whether it be put him in jail for contempt of court, for failing to comply with the court order, or suspending the driver's license. Now, what the individual, when they see themselves faced with an inability to pay the amount that has been ordered by the court, they need to immediately, don't wait until it becomes in arrears and delinquent, they need to immediately go to the family division of the circuit court clerk's office. They have fill-in-the-blank forms. They will help a person. You would file a supplemental petition for modification saying that there had been a substantial change in circumstances, and that the fact that there is a final judgment or a court order that ordered that individual to pay X amount of dollars a month for child support, and that individual, despite his or her best efforts, cannot pay that amount. Then you ask the court to give you relief in the way of a modification, whether it is a reduction, even if it's a temporary reduction, or what have you. If you do that, the court will enter a supplemental order and you will not be at risk. If you sit back and do nothing and stick your head in the sand and just wait until the arrearage has built up to a substantial amount of money, you're very unlikely to find much sympathy with the court. And you would have the burden of showing why you couldn't pay it, because the amount of child support that is originally ordered is based upon the premise that the individual has the ability to do that. And if the person loses that ability in the future because of an accident, because of injury, because of illness, because of loss of a job, or other reasons that are not voluntary, not anticipated, not something that is just merely transitory or temporary. I woke up this morning and said, well, I can't go to work because I have the flu, so I didn't get paid. That's kind of temporary type situation, as opposed to being in a car wreck and having your leg broken and being in the hospital with surgery for 6 weeks or something like that. So I would encourage someone, and you don't need to hire a lawyer for this. The Family Law Rules of Procedure has extensive forms, and the clerks are trained to help people fill out those forms, and it's a fill-in-the-blank form. And you go there, and they have very, very clear, concise instructions on how to do it, and you file a supplemental petition for modification, and you put in there the reason why you can't pay the amount you were ordered to pay. And then you file a supplemental financial affidavit together with your pay stubs and your tax returns showing what you can pay. And then you have a hearing before the judge, and if what you say is confirmed by the evidence and is truthful, and the court determines that you are doing your very best and that you cannot earn enough money to pay the previously awarded child support, then the court will reduce that. And they'll reduce it retroactively to the date you file the petition.
Does the opposite happen? Does the recipient parent get the opportunity to also fill in forms? Hey, my ex is now making a lot more money.
Exactly so. Okay. The court has continuing jurisdiction over all matters concerning child support, parenting plan, time sharing, visitation, all of those things for modification at any time that there is a substantial change in circumstances. So if at the time a couple are divorced, child support for the child or children was $1,000 a month based upon the combined net income of both parents then, and later one of the other parents' income goes up dramatically, then child support would be recalculated. The determination of the amount of child support is all done by a formula that's set forth in Chapter 61 of the Florida statutes. And you put in the net monthly income of the husband, ex-husband, the net monthly income of the spouse or ex-wife, ex-spouse, and the number of children that you have, and you have a table. And of course, I'm simplifying it for purposes of explaining it in this program, but it determines what is the amount of child support. And let's say the amount of child support is $1,000 a month, and the spouse number one is making, and I'm just using round numbers for simplicity's sake, spouse number one is making $600 and spouse number two is making $400, and there's a combined total of child support of $1,000. Then spouse number one would pay 60% of that $1,000 or $600.
Makes sense, yeah.
Okay, yeah. And that would and the order that is originally entered that determines that is presumptively reasonable. It carries a legal presumption that this is the correct amount and that both parties have the ability to pay that amount. Now, no one has a crystal ball. No one can predict the future. So the law, in order to be fair, says if you come back to court and you tell us about it and you show us the evidence that proves it, that you just didn't take off from work 3 days a week and go play golf or go fishing, that you still continued to work and to do your best, and for circumstances beyond your control, you no longer have the income that supports the payment you were to make, then the court will modify that appropriately. And if you do that, you're not going to be at risk for having your license suspended or going to jail for being in contempt or in violation of a court order.
Always fascinating, John, and it's always clear why people hire you to be their attorney. Obviously, you know your stuff. John, what is your phone number?
We have offices in Ocala and the Villages. Our local number is 352-547-4292. Our toll-free number is 855-534-2565. If you have a legal problem and we can help you, please call us. We'll be happy to try to do so.
Good to see you again, John. Happy New Year again.
Enjoyed it, and thank everybody for listening and calling in.
Great show, as always. We will take a little break, and we'll be right back. Call us if you need John's number repeated. We'll be glad to do that for you over the phone. We'll be right back.
Ocala's information station, 1370 WOCA.
ABC News Now. I'm Karen.